Public Bills, second reading.
Yes, Honourable Attorney General, welcome.
Thank you. Madam Speaker, I move that the Constitution Amendment Bill number 10 of 2025 and the Criminal Code Amendment Bill number 11 of 2025 be read together a second time. Madam Speaker, the Constitution Amendment Bill fulfills the commitment given by the state before the United Nations Committee Against Torture, but above all, it upholds the democratic values which this government wants to restore, strengthen, and extend. The bill seeks to repeal Section 7, subsection 2 of the Constitution, which currently allows punishments found in laws that were in force in 1964, which punishments may now be considered inhuman or degrading, to remain constitutionally valid. Madam Speaker, in its concluding observations on the fourth periodic report of Mauritius, the United Nations Committee Against Torture gave its concern at the lack of express provision in our law prohibiting torture in absolute terms. It recommended that no justification whatsoever should be allowed for acts of torture in accordance with Article 2, subsection 2 of the Convention Against Torture. It also drew attention to the need for other laws, including Section 245 of the Criminal Code, to align with this absolute ban. The committee further emphasized in its general comment, I'm trying to replace my friend Bagwan here, that state parties are obliged to take legislative and administrative action to reinforce the prohibition against torture and to eliminate any legal obstacles to its eradication. Torture is the subject of a non-derogable prohibition. No state may invoke any circumstance, however exceptional, to justify it. At the fifth periodic review of Mauritius in April of this year, I therefore informed the committee on behalf of our government that Section 7, subsection 2 would be repealed. Today, Madam Speaker, barely a month later, we are giving effect to that promise. Yet another example of the commitment of this government to leave no stone unturned to reach our ultimate goals. Madam Speaker, Section 7 of the Constitution is made up of two provisions, and it bears necessity here to read them out in extenso. Subsection 1 reads, "No person shall be subjected to torture or to inhuman or degrading punishment or other such treatment." However, subsection 2, Madam Speaker, states that nothing contained in or done under the authority of any law shall be held to be inconsistent with this section to the extent that the law in question authorizes the infliction of any description of punishment that was lawful in Mauritius on the 11th of March, 1964. Section 7, subsection 2, thus creates a broad exception to the constitutional protection against inhuman treatment. It immunizes from challenge any law that was in place before independence, even if that law authorized punishments that are unacceptable by today's standards. Moreover, that same subsection 2 of Section 7 of the Constitution is often misunderstood as a transitional clause, but its effect is broader and more enduring. It allows such punishments to be reenacted through new laws, which will then remain immune from constitutional scrutiny as long as they mirror what existed prior to independence, 1964. For example, corporal punishments such as flogging or whipping, long abolished in Mauritius, were once lawful under colonial rule. In countries like the Bahamas, such punishments were repealed and later reintroduced without being struck down due to the existence of these quote-unquote saving clauses of similar nature. Madam Speaker, the Judicial Committee of the Privy Council has examined such saving clauses in several cases, such as Pindar in the Bahamas, where a similar clause allowed colonial punishments to be repealed and later reinstated, Watson in Jamaica, Philibert in Mauritius, where colonial laws were given immunity from constitutional scrutiny, and more recently Reyes in Belize, where by contrast the Belize constitution made such law transitional for only 5 years post-independence. But even then, the Privy Council held that when there is no time limit set, the clause is not transitional, and its effects endure indefinitely. But these clauses, Madam Speaker, were only introduced with the intention of ensuring legal certainty and to secure an orderly transfer of power from colonial regimes to independent ones. They were not meant to hinder democratic progress of nations decades after independence. Madam Speaker, the court's task in fulfilling their role is to interpret the Constitution by ensuring that its construction adapts to changing times and that all local laws of the jurisdiction conform with the organic growth of the Constitution. This is the living tree doctrine, as described by the Privy Council in the very old case of Edwards and the Attorney General of Canada. In that case, women were not considered to be persons under the definition of a local act. However, the Privy Council stated that the term persons should be read broadly, and preventing women to become members of the Senate in Canada was, and I quote, a relic of days more barbarous than ours. For the Privy Council, and we agree fully with that proposition, a constitution should thus be capable of growth and expression within its natural limits. Madam Speaker, Section 7, Section 2 remains on our law books. The risk persists that one day Parliament could, not this one of course, but one day Parliament could reintroduce archaic punishments, and that such laws then be shielded from constitutional challenge. We cannot, as a responsible government, allow that. This approach would prevent the interpretation of torture or inhuman or degrading punishment to ever evolve, similar to the definition of persons in Canada under the living tree doctrine. It would be a Damocles sword hanging over our legal order. This view was in fact adopted by the Privy Council recently in the case of Chandler, Trinidad and Tobago case of 2022, where it was again emphasized that the existing laws could not be held unconstitutional, but parliaments were nudged, to use a soft expression, by the Judicial Committee to repeal and amend such laws. Repealing Section 7, Subsection 2 of the Constitution, therefore, Madam Speaker, is just not symbolic, it is necessary. I now turn to the Criminal Code Amendment Bill, which accompanies this constitutional reform. This bill revises two provisions, Section 245, which governs the use of force and the lawful authority, and Section 242, which excuses manslaughter upon discovering adultery. First, the repeal of Section 7, Subsection 2 of the Constitution requires us to revise Section 245. Its existing language, therefore, no longer aligns with the updated constitutional standard. The new provision ensures that the use of force, including lethal force, remains legally justified, but only under defined conditions, which are A, the defense of persons or property, B, the lawful arrest or the prevention of an escape, C, the suppression of a riot, insurrection or mutiny, and D, the prevention of a criminal offense. This is consistent with international norms, with common law principles, and with the doctrine of proportionality, which is now implied in our Section 7, subsection 1, soon to become Section 7, simpliciter of our Constitution. In other words, even in these justified circumstances listed A, B, C, and D, force must be used reasonably and cannot amount to inhuman or degraded treatment or torture. Madam Speaker, let us now turn to Section 242. Before I deal with it, let me read in French from the Old Code Napoléon what that section says. Le meurtre commis par l'époux sur son conjoint ainsi que sur le complice à l'instant où il les surprend en flagrant délit d'adultère est excusable. You will have noted that the excuse would only apply to the male and not to the female. That provision, as I said, inherited from Article 324 of the old French Penal Code, provides that manslaughter committed by a person upon catching his spouse in the act of adultery is excusable. In effect, and as per French jurisprudence, only a man convicted under these circumstances will get a reduced sentence. France repealed that section in 1975. 50 years on, we are still at it here and having to debate this in Parliament. But hopefully, this will be a thing of the past in a couple of hours. Although Section 242 of the Criminal Code has not been applied in a Mauritian court, it remains on our books and it remains the law of our land. And that in itself presents a legal and a constitutional risk. It offers a blanket excuse for killing based solely on emotional provocation. This excuse lacks any consideration of proportionality, intent, or judicial discretion. And that is problematic for at least three reasons. First, Madam Speaker, it is incompatible with our Constitution. Let us not forget Section 3 guarantees individual rights. Section 16 prohibits discrimination. Section 242, in contrast, is at its core rooted in unequal treatment, where only male violent reaction is deemed excusable. No such provision exists to excuse a woman who would find herself in similar circumstances and kill her spouse. Secondly, it contradicts the general framework of our criminal law, where the notion of provocation is already recognized and considered on a case-to-case basis by our judges and magistrates every day in court. Section 242, therefore, imposes a redundant and rigid rule that bypasses judicial assessment and discretion. Thirdly, Madam Speaker, it is socially harmful. How can anyone look at our younger generations of this country and tell them that in our law there is a provision that could excuse feminicide? What message would we be sending to the country where domestic violence has been left unchecked for years? International bodies have echoed this, Madam Speaker. The United Nations Committee Against Torture in 2017, the Committee on the Elimination of Discrimination Against Women in 2018, have both urged a repeal of this section, but nothing was done by the previous government. Madam Speaker, I must stress that today's reform is not being carried out merely to satisfy external recommendations. It is being done because the provision is out of place in our legal system and constitutional principles. Repealing Section 242 simply removes an aberration that should never have been preserved. Madam Speaker, these two bills remove provisions that no longer belong in our constitutional order. They reflect our responsibility to update the law, not only and merely to preserve its letter, but to uphold its spirit. There are, of course, more sections of the law, including some in the criminal code, that must also be reviewed in the same spirit. For instance, we are presently working on a bill to update and refine our legal arsenal on sexual offences and to better fulfill not only our international commitments, but also our moral obligations to the women, girls and boys of this country. For today is but one step of many more to come, steps which will include the giant strides that the forthcoming Constitutional Review Commission is expected to make. And step by step, slowly but surely like this, Madam Speaker, we will cross our government's bridge to the future. I commend both bills to the House.
Yes, motion is seconded.